So today we are going to discuss about the Contract Act. So what is the need for Contract Act? So before the implementation of contract law, there is no specific law for particularly contract. So what is the meaning of contract? If I am doing a particular activity with another person, there is a need for a written agreement. And what we are going to do? First is what we are going to do, and second one, if I am getting any benefits through the contract or else or a particular event, and what will be the sharing or else benefit. Okay, to know this, we are implementing a written agreement through the contract law, and it helps to avoid disputes between the persons. Okay, and in ancient and medieval times, and there is no written contract, and Hindu laws followed a separate Shastras and Vedas and Smritis and Dharam. Okay, and contract is based on a free concern. Free concern means nobody should threaten somebody to do a certain thing. For example, I am threatening my daughter to, if you do this activity na, I will give you the chocolates. If you do this na, I will beat you. Like this, nobody will tell to someone to do a particular activity. Next one, during the Mughal period, they followed a Muhammadan law of contract, and in this law they used some Arabic terms, and you please recall these terms. If this Arabic terms are asked in the MCQ na, we need to answer this. At Q means contract, and ijab means proposal, qubal means acceptance, and we will discuss these terms in later. Okay, and in Mughal period there is no need for a formal contract between the two parties, and mutual consent is necessary to implement a particular contract. What does mean by mutual consent? For example, I am ready to sell a Honda car, okay, and another person should be ready to buy that Honda car, right? And this is called as mutual consent. Next one, key Hindu law views, and if I am going to enter in a particular contract and they implemented a certain criteria. First one, minor and lunatic or else unsound mind persons, mentally if they are not well, and elderly and handicapped people. These people are not capable to enter in a contract. Okay, and they set a age criteria also. If a child is up to 8 years na, they will call a child an infant. If their age is between 18 to 16, they will call a boyhood. If 16 plus na, they are capable to enter in a contract. And now the minor category was 18 plus. Now they changed. Okay, during the British period they followed a English contract law, and it is applied on a Madras, Bombay, Kolkata, and it has a charter 1726 onwards. And after independence they are going to implement a separate law for contract, and it came into existence on September 1st, 1872, and it is applicable to the whole of India including Jammu and Kashmir. While reading a law, we need to understand when the act came into existence and whether it is applicable to the whole of India or else except Jammu and Kashmir, or it is including Jammu and Kashmir. First we need to understand this, then we have to read further. And while implementing the contract law, they have divided the particular law into a 4 part. First part is related to the general principle related to contract. So first part is dealing with general rules and regulations related to the Contract Act, and second part is related to the Sale of Goods Act. While selling a particular goods, I have to follow the Sale of Goods Act, and previously it was a part of contract law, but now it was replaced with the Indian Sale of Goods Act 1930. And third part is related to the special contract like agency, bailment, pledge, etc. Next one, law relating to the partnership business. While implementing a partnership business, I have to follow these rules also. Now it was replaced with the Indian Partnership Act 1932, and we have a separate act for the LLP, that is Limited Liability Partnership. In this partnership, partners' liabilities are limited to a certain level. Okay. And next one, structure of the act. Part 1 is dealing with the general principle, and part 2 is dealing with the special type of contract. We will discuss these kind of contracts in a later chapters. Okay. Next one, importance of a contract law. Why I need a separate law for contract? And nowadays people are doing a lot of business activities and trading activities. To avoid the conflicts, and we have to define what are the rights and duties of a parties who are involved in a particular contract. So for that purpose we need a separate law, that is called as contract law. Okay. And this law helps to define and what will be considered as a valid contract and what is a void and voidable. So valid means I can legally enforce that contract without any issues, and if it is a void means I can't enforce or else implement that particular contract. And voidable means it is a valid contract at the initial stage. Later the parties rejected that. Further we are not going to proceed with the contract. We are going to cancel the particular contract. For an example, A and B are doing a particular contract. For example, we can take a sale of car. So A is going to sell his car to B, and A is demanding for the price of 20 lakhs, but B is not ready to give that 20 lakhs, and B is ready to give 15 lakhs. In this concept, price is not matching, right? And this case, disputes will arise, the problem will arise between the parties, so they will drop the procedure. So this is called as voidable contract. Okay, and also we can determine the special type of contract also. And key elements of a contract law. First one is offer. Offer means I am going to express my willingness to another person. Acceptance means I gave offer to A. If A accept that particular contract means that is called as acceptance. And revocation means cancellation. And valid, void, voidable, already we have discussed this. And conditions under which promise becomes legally binding. So next one we are going to discuss about the definition under the Contract Act. First one, contract. Contract means it is an agreement between the two or more parties that is legally enforceable, or is legally we can implement that particular contract. Okay. So highlight this. One second, we'll remove this example. And next one, agreement. So agreement means every promise and every set of promise forming a consideration for each other. For example, I am ready to sell my books to another person, and for that selling I will fix a separate price. In this example they have given it as 100, right? So consideration is very important while framing a contract or else agreement. Okay. So what is an agreement? I promise to another person that will leads to consideration for each other. Okay. So in simple word, agreement is equal to I am going to express my willingness to another person, and that person has to accept that, and there will be a particular price for that. Okay. So highlight this. And they get another example also. A promised to sell his house to B for 5 lakh. Here is the promiser. A is ready to sell his house, and A is the promiser and B is the promisee, and A is going to express his willingness. Also we can tell A as a offerer and B as a offeree. Okay. Next one, difference between agreement and contract. So what is meant by agreement? I am going to provide a promise that will leads to frame a consideration. This is called as agreement. And contract means already I have designed one agreement. Now I am going to impose that agreement legally. That is called as contract. Okay. And in simple term we can tell like this. Agreement is a first stage. After framing an agreement, we have to register that and we have to follow the rules and regulations which is prescribed under a law, right? And next it will move to the second stage, that is called as contract. Okay. And agreement has a wider scope and it will cover social and legal agreements also. Legal means as per law I have to follow these rules and regulations. And if it is a social means there is no legal rules and regulations. For example, one person is climbing a tree and that person has fallen down. Okay. In this case what I have to do? I have to help that particular person. This is not prescribed under any law. This is called as humanity. Like this, any agreement is framing that also will cover under agreement, but in a contract only the legal terms will be covered. Social agreement and social contracts will not be included in a contract. And agreement will not create any legal obligation between the two parties, but contract will create a certain rights to the parties. Okay. Next one, proposal or else offer. So proposal or else offer means I am going to express my willingness to another person. I am ready to do this particular activity, or I am not ready to do this particular activity, and this is called as proposal or else offer. Okay. Expressing a willingness to do or not to do or else abstain from doing something is called as proposal or else offer. Okay. Underline these important terminologies. As per section 4, if there is any vague in a contract, offer can be rejected or else revoked. Vague means the terms which is included in a contract that is not clear. Okay. For example, I am ready to sell my house for the Mr. B. Okay. And I am going to tell Mr. B that you can use all spaces in my house, but you should not occupy my kitchen or else hall. Like that I am restricting. I have to tell that information prior before signing an agreement. Okay. So the terms in a contract is not clear, the other party can reject or else cancel that particular offer. And next one, conditions for that offer. if offer is there, we have to follow these 4 conditions. First one, my offer has to be definite and clear and complete and final information. So incomplete informations now I should not provide, and it should be communicated to the offeree, that is opposite person, and it can be a writing or else oral. Either I can give it in a letter format or else document format, or else I can tell in a oral format. And fourth one, it can be expressed or else implied. Expressed means detailed information, and there is no room for confusions. Okay, I gave A to Z all information to the opposite party, that is called as expressed, either through a word or else written. I gave a detail, but implied is just opposite. I did not give any information directly. So what it means? Indirect informations I gave. Okay, we can take an example. I am going to join in a particular private school. That particular private school has a certain rules and regulations. I have to follow that school's rules and regulations. Whether as anybody is telling you have to follow these rules and regulations, or else you will not anymore hear. Like that, is anybody telling to you while putting an admission? No, right? So that is called as implied. It is not explicitly stated, but we have to follow that. So they gave an example. Read that. X offer Y to sell his car for 5 lakh. Such proposal is called as offer. Okay. Next one, acceptance or promise. Again and again we are discussing the same thing only. Right. I express my willingness to another person. When another person accepts that, it will become a promise. And for acceptance or promises also we have certain conditions. First one, as against the proposer when it put in the course of transmission to him as to out of the power of the acceptor. One second. In the promise we are having two parties, right? One second. What has happened? One is a promiser and second one is a acceptor. Okay. So what they are trying to telling means, I am going to express my willingness to another person, right? And for example, if A express his willingness to B and A part is got over, and after that he can't resign that. I didn't say anything. Like that, A can't sell anything. And if B accept that particular project, I am ready to buy A's car for 5 lakhs. Like that, B is ready to accept, and hereafter they can't resign. When this information has to be passed into Mr. A. Okay. And just read this, and if you have any doubt, and let me know. Next one is consideration. While involving in a contract, consideration is a very important component. Without consideration, a contract will not become a valid one. Okay. One second. Underline this. Write it like this. Consideration means something in return. Okay. So I'm going to do a particular activity, or else I'm not going to do a particular activity. For that I need something in return. That is called as consideration. Next one is called a reciprocal promise. Both parties are undergoing a mutual agreement. That is called as reciprocal promises. For example, A is ready to sell a car to B, and instead of giving an amount, B is ready to do some favor for A. Okay, this is called as reciprocal promises. Next one, void agreement. Already we know void agreement means that is nil. We can't enforce this particular contract, and if it is a voidable, we can enforce that particular contract, but the parties involved in a contract will cancel that. We are not going to proceed anymore, like that they stopped a particular contract, that is called as voidable. And void contract means also same, we can't enforce that. Okay. Next one, when an agreement will become a contract. So agreement will include social and legal obligation, which is already we have discussed this part. Social obligation means there is no legal law or rules and regulations, but if it is illegal, we have to do a certain activity. Okay, so it is a mandatory requirement, but social contract is a responsibility, or else we can add like that humanity. Okay. So only legal obligations will be considered as an agreement, and certain important components are given here. Agreement can be oral or writing, it can be expressed or implied, and it can be in a prescribed manner. For an example, while preparing an agreement, I am telling to that opposite party, we have to follow these procedures, and if we are transferring any payment, we have to transfer through our bank account only, or else GPay, PhonePe, check, like this modes only we have to use. That condition I levied on that particular person, that condition has to be followed till the end of the contract and accepted in a prescribed manner. I am telling that my opposite person, you can express your willingness through the mail or telephone or else telegram, and that person has to follow that prescribed modes only. And conditional acceptance. For an example, we can take a car itself. Okay, A ready to sell his car to B, but what B is telling now, I'll buy your car when it will reach 1 lakh kilometers. So my car has to run 1 lakh kilometers. Okay. So in this case, B is levying a certain conditions for the acceptance. It will leads to a rejection. Next one, mere silence. I didn't express my willingness, or I reject, explicitly I didn't reject anything. That will not consider as a acceptance. If I am staying and I am remain silent, it will represent I didn't accept that contract. Okay. Next one, essential elements for a valid contract. This element has to be there in a contract. First one, offer and acceptance. I have to express my willingness to another person, and that person has to accept my contract. Next one, lawful consideration. So something in return value should be there. If there is any return value is not present, that will not consider as a valid one. Next one, free consent, and other parties should not threaten a particular person to do a certain activity. And next one, enforceable by law. I can proceed as per legal rules and regulations. And next one, parties. There must be at least 2 parties to enter in a contract, and these parties have to sign an agreement. That is also an important component. Okay. So we will discuss one by one. First one, free consent. So it is, a contract is made as per my willingness, and nobody should threaten myself or my family. Okay, so they give an example. A threatened to shoot B if B does not lend him 2 lakhs. Okay, if you are not giving 2 lakhs, I will shoot you. Like that, I am threatening another person to give me an amount, na, that is called as not a valid one, and legally I can't enforce that particular contract. Next one, lawful consideration. Something in written has to be there and it must be a real and lawful. Illusionary thing should not be present. For example, I am going to found treasure by magic. This is illusionary. This type of consideration should not be presented in a contract. Next one, parties are competent, and the parties who are involving in a contract, they should have that some capabilities and capacities to enter in a contract, and they should be sound mind person and 18 plus, and he should not disqualify from any law or as contract act. Next one, legality of an object. If I am going to do anything, there must be a legal object, lawful object should be present there. For an example, I am going to appoint another person to kill Mr. B. Okay. So whether is there any legal object in this contract? No. Whether it will be considered a valid one? No. Okay. And a contract should create a legal relationship between the two parties. Next one, agreement are not explicitly declared to be void. So expressly I have to give all information. Okay. And they gave some examples related to this. Read that. A husband agreed to pay to his wife a certain amount as a maintenance for every month. Okay. For an example, we can take like this. Husband and wife is there. Husband is in the abroad. Okay. And wife is a homemaker. She is not ready to work, and her health condition is also not supporting. Okay. And what husband is saying now, I will give you a monthly 20,000 amount for the maintenance of house. Okay. And due to certain reasons, husband is not giving this 20,000 for 1 month. In this case, wife can't able to file a suit or case against that husband, because legally it is not a valid one, because it is a social agreement. Law is not telling anything. Husband has to give amount to that wife. Okay. So it will be considered as a social agreement. There is no legal relationship between the two parties. So it will be considered as a void one. Next one, consensus of ad item or is making of mind. Okay. So we can take an example. A is ready to sell a pen to B, but B need a fountain pen. But A is giving a Parker pen. Okay. So whether B will buy A's pen? No. So there is no meeting of mind. So same example, Honda and Pulsar they gave. Okay. Next one, certain and capable of performance. So I should be capable for doing that particular performance. Next one, legal formalities and legal rules and regulations also I have to follow. And please strike out this, it is a repeated content only. Next one, types of a contract. So contract is divided into 5 parts. Okay. So first one is based on enforceability. If legally I can enforce that particular contract, that is called as valid one. And if legally I can't do anything, that is called as void agreement. And what is meant by voidable? Legally we can enforce that, but the parties are not ready to that particular thing. Okay. Next one is void contract. So it is not valid as per legal rules and regulations. It will be treated as void up at the initial. So what it means now, at the initial stage itself, it will become a void one. Next one, unenforceable contract. We can't enforce these kind of contract anymore in the court of law due to this some technical defects or that in a particular contract. Next one is illegal. Legally it is prohibited. For example, selling for drug is restricted as per law, but one person is selling a drug to another person, that will be considered as a illegal contract. Next one, based on the formation. First one is formal. Even though these contracts are lag in a consideration, it will be considered as a valid one. And these kind of contracts are segregated into a two category. One is contract under seal and another one is contract of record. Contract in seal means that particular contract should be in a writing and it should be signed by the parties, those who are involved in a particular contract. Next one, contract of records. A contract of records means, we can take an example of court judgment. Based on the judgment, we can proceed further. For an example, similar kind of cases occurring in another place, I can consider that case also and I can claim that judgment also. Okay. Next one, simple contract. Apart from the formal contract, other contract will be called as simple contract. Next one, on the extent of performance. So first one is executed. What it representing? It is a past tense. It is over. Completely I done the particular performance, that is called as executed. And if it is a executor in a, what it's representing? Future tense. I am going to that particular activity on a future period. Okay, no? Next one, based on a obligation. So based on obligation, we are having three category. One is unilateral contract. There will be only one party. So already we read that to involve in a contract there should be at least two parties, right? But this kind of unilateral contract, we don't need two parties. One party is enough for doing a particular transaction. Okay. For example, I am going to book a ticket through the online portal. Okay. Whether I need anyone's help? No. If I book the particular ticket, now my work will be get over. When the trains came, I have to reach that place, right? So this kind of contract will be called it as unilateral contract. Next one, bilateral. So bi means two parties. Okay. Next one, multilateral. More than two parties are there now, that type of contract will be called it as multilateral contract. An example for this contract is partnership and joint venture. Next one, mode of creation. First one, express. So what it means? I am going to express all related informations, detailed procedures to another party, either word or oral. Okay, that is called as expressed contract. And if I didn't directly express anything, that is called as implied or is inferred contract. Next one is static contract. So static contract will be performed as per the situation. For example, drawing a cash from a ATM. So for this cash withdrawal, I have to follow certain procedures. I need a ATM and bank account. I should have a bank account also, right? And if there is no bank account, now I can't withdraw any amount. And sufficient balance should be there in my account. Okay, these kind of rules and regulations or as conditions I have to meet. Then only I can able to withdraw a cash from a bank. So what it means now, it is an arrangement between the two parties to achieve something. For that purpose, they will follow a separate procedures. Next one, e-contract. Instead of giving a paper based contract, I am giving in an electronic format. Abdina, that is called as e-contract. Okay. Next one, offer and acceptance. Already we have discussed this. What is meant by offer? Offer means I am going to express my willingness to do a particular thing. What is meant by acceptance? And another person need to accept, right? And there will be an involvement of two parties. One is called as promisor or else offerer, and another one is a offeree or else promisee. And they should express their willingness to do or not to do something, and it can be expressed or else implied, and it can be positive or else negative one. Next one, types of offer. Offer can be an expressed or else implied. So already we have discussed these terms in depth. Okay. So what is meant by express? I am going to give you detailed informations, and there is no room for confusions and controversies. And what is meant by implied? They will not tell anything detailedly, but indirectly it will represent something. Okay. Next one, offer and invitation to offer. What is meant by offer? I am going to express my willingness to another person, that is called as offer. But invitation to offer means expressing a willingness to enter in a particular contract. Okay. And offer can be accepted by the offeree. Who is called as offeree? The person who received that offer is called as offeree. That person has to accept that. But invitation cannot be accepted by the person whom it is made. So who make that particular offer, they can't accept it. Okay. And an offer, when it is accepted, it will become an agreement, but an invitation to offer cannot accept it at all. Next one, general offer. General offer means it is going to represent a lot of persons. If any person is fulfilling that particular conditions, they can enforce that particular contract, and it stays open until a complete withdrawal. Okay. For that purpose, they have given one case study: garlic versus garboil smoke ball. And Garbolic Smoke Ball is a company. They are producing a smoke ball, and what they are doing now, they are going to do a particular advertisement. If you are following these procedures now, we will give a reward up to $100 or is euros. We will give like that. They advertised, but one person had followed that all procedures, but till now that person didn't get any reward. And what the court said now, it is a general offer. You are going to represent a lot of people, so you have to pay that particular person called Gorlil 100 euros. Okay. Next one, specific offer. An offer is said to be specific when it is addressed to a definite person. If it is representing a large people, it will be called as general offer. If it is representing an individual person, it will be called a specific offer. I am going to sell my car to Mr. B, and it is representing Mr. B and A. So it is a specific. Next one, cross offer. For an example, I am telling A is ready to sell his house to Mr. X for 5 lakh, and without knowing this, B also approaching Mr. A to buy his house for 6 lakh. Here what is happening? Both the parties are expressing their willingness to an another party. Both are an identical offer, but they didn't know, right? And these kind of offers will be called as gross offer. Next one, counter offer. Like bargaining things will come na, it will be treated as a counter offer. We can take this example. So A is ready to sell his house to X for 5 lakh, and what X is telling na, I am not ready to buy your house for 5 lakh, but I will pay for 4 lakh 50,000 only. That is not worthable for 5 lakh. Like this X is telling na, this type of offer is called as counter offer. Negotiation part will comes na, that is called as counter offer. Okay, so you can keep that word in your mind, negotiation. Okay, next one, legal rules regarding an offer. So either offer can be expressed or else implied, and it should be specific, and there should be a legal obligation, and it should be certain and definite. And what are the terms which is involved in a contract? Now I have to say that all information is on a clear basis, and it should be communicated to the opposite parties, and I have to consider other person's opinion also. Okay, and in simple word, offer can be defined like this. It can be act of doing something or absistence of doing something, and it can be a word or else. Through the conduct or else behavior of a particular person, it can be written or else oral. Okay.